matter of fact discovery, chair and etc. Your lordships have examined the fact specific situations. In fact, it never required a reference. I'll assist your lordship. Can we come to 7.1 again, my lord, in the context of your lordship's my lord, illustration that a builder having a separate agreement contract with A, with separate with B, separate with C, and some dispute between A, B, C, D. Now please see, it is in this part, arbitration agreement means an agreement by the parties. So builder can't be roped in unless there is something to suggest that he also has acquired certain responsibilities.
Way that dispute, the way the
And it should be resulting into some kind of a defined legal relationship, which may be contractual, which may not be contractual, which may be, my lord, arising in case of, my lord, illustration like this nature, my lord, easement. Whatever, my lord, I'm not giving examples. My lord, now I'll move forward. My lord, there was a reference that there is a law commission's report. My lord, 246th law commission report. I'll finish it in 5 minutes. This law commission report one. But there was a suggestion. There were two suggestions. Page 7. A. The law commission merely recommended amendment to section 2(1)(h), that is parties, and not to section 7 of the Act. In other words, even the law commission did not find that without amending both section 2(1)(h) and 7, group of companies doctrine cannot be statutorily recognized. They never said that you amend section 7. B. The said definition was not required to be mandated as the suggested definition. If read, my lord, your lordships can skip, my lord, I have reproduced and possibly somebody has read, my lord, 61 to 64 of law commission's report before your lordship. But C. When section 7 provides for a permissible dispute resolution, even amongst the third party, even if they are not contractually bound with each other, mere enlarging the scope of the term party to add person claiming through or under such party, that was the amendment suggested, may perhaps restrict the wider meaning of section 7. And therefore, my lord, maybe that is not accepted. Lord, I hope, Lord, I am able to make myself clear. Section 7 is very widely worded so as to include every kind of legal relationship if there is an agreement shown to exist, whether agreement is contractual, not contractual, irrespective of that. Now, if the definition of section 2(1)(h) is amended, it would restrict that either person claiming through him. So possibly that can be the reason it was not, my lord, amended. The officer of the law ministry is here, my lord, with the record. I don't want your lordship to see, but if your lordship wishes, I can place it, my lord, and your lordships can see them. I can show it to others.
Is there anything specific in that?
Lord, the only thing is, my lord, that there is a table. The law commission suggested several amendments. Left-hand side column mentions the suggested amendment. Right-hand side column mentions the response of the law ministry. On 2(1)(h), they say should be accepted. But thereafter, it never materialized when a bill was prepared, which became an act in 2015, the Amendment Act. So that is.
So it was accepted in the law ministry, but it
didn't materialize, and there is nothing on record we have checked up to show why that happened, whether inadvertence, a conscious decision.
Gone up in the pool.
To explain that restrictive meaning was avoided.
Yes.
They wanted to keep the expression enough to take into account all kind of possibility scenarios.
As contemplated under 7.
As contemplated under 7.
Otherwise,
that 7 is wide enough to take.
2(1)(h) as suggested to be amended may perhaps restrict 7. Because then it would be parties. Party would mean either party himself or someone claiming through him. Then, even if there is a defined legal relationship emerging, even if an act of agreeing, without there being any formal agreement emerging.
But the notes in the ministry do not suggest that consciously such a decision with this intent.
It is not. I must frankly, my lord, admit
it was just not gone through. Although
It
recommended.
didn't go through, my lord, that's all. But I'll place, my lord, the file for your lordship's consideration. Lord, section 8, I don't wish to, my lord, dwell much. It merely gives an additional locus. Earlier, my lord, what used to happen, if contracting parties are before a civil court or any judicial forum, only the party can say that send us to arbitration or send them to arbitration. Now, my lord, even any other person claiming through or under him also can do it. It gives additional locus in section 8, nothing beyond it. Lord, it doesn't affect the applicability or otherwise of the group of companies doctrine.
Yes.
Lord, page 10, para 22, my lord, the heading, my lord, I'll not, my lord, dwell much, but my lord, I'll just orally point out in 2 sentences that the very object of the act is to ensure that dispute A is resolved fast. This second, it is not fragmented. If someone is really a part of a defined legal relationship, then I'll fight with A in an arbitration and I'll fight with C in a civil suit. That is avoided. So your lordships would avoid a meaning which defeats perhaps the intention of the legislature. Lord, now page 11. Lord, your lordships may not again read it. I'll just orally point out what my submission is. May I read, my lord? Or
Yes. Page 11.
11, para 28. Lord, the submission is that every jurisprudential doctrine may not have its foundation or basis in a statute. Lord, Lord, without reading it, I'll just orally point out what my respectful submission is. Lord, the legislature provides the letter of law,
Yes.
and your lordships, by judicial interpretation, infuse the spirit and blood in it. And that is, my lord, the doctrinal approach. Lord, for example, doctrine of estoppel, Lord, doctrine of legitimate expectation, nowhere to be found in any statute.
Promissory estoppel.
Promissory estoppel, my lord. There are, my lord, the doctrine of piercing corporate veil. It's not part of any statute. Doctrine of proportionality. It's not a part of any statute that it has the punishment or act should be proportionate to what is being dealt with. Then doctrine of causes omissus. So, my lord, jurisprudence evolves once the letter of the law is interpreted by your lordships and your lordships infuses blood and soul in that letter of law provided. If it defeats the very intention of the act, my lord, it cannot be accepted. Suppose there would have been a doctrine in the arbitration context which would have defeated the very object of the act. Then your lordships may in a 5-judge combination say that no, this doctrine is not applicable. But it furthers, my lord, the object of the act. It supplements the intention of the legislature. Lord, now the question is, when there is statute, silence in the statute law, can the doctrinal approach be incorporated while dealing with that law? To put it differently, when this was an argument, that when there is no reference to group of companies doctrine, can you read that into section 7 or any other provision merely as a doctrine which is evolved by judicial interpretation? Lord, there is a recent judgment of the United States, my lord, United States Supreme Court, my lord. And allow me to read that page 30 in arbitration. In arbitration, my lord. Lord, therefore, my lord, before I read it, my lord, please examine. There are several countries broadly classified as those who have adopted the model law of UNCITRAL, those who have not adopted the model law of UNCITRAL, but all have their domestic laws, maybe fully in conformity with UNICITRAL, maybe partly in conformity with UNICITRAL, maybe completely different from UNICITRAL. Whether they can use the doctrinal approach or not, as per their domestic policy. Suppose India is UNICITRAL compliant law. Can we not have some doctrine? Lord, that is answered by the Supreme Court of United States at page 13. Lord, the citation I have given, Lord, and I have placed, Lord, the judgment also, my lord, GE Energy Power Conversion Finance. My lord, para 13, my lord, may I read this judgment, my lord? This silence is dispositive here because nothing in the text of the convention could be read to otherwise prohibit the application of domestic equitable estoppel doctrine. Now, please mark it. Equitable estoppel doctrine is a facet of group of companies doctrine. I'll show you. Equitable estoppel doctrines. Because I will be stopped from saying something which I did, which resulted into a defined legal relationship. Only one article of the convention addresses arbitration agreements, Article 2, and only one provision of Article 2 addresses the enforcement of those agreements. Article 2.3. The text of Article 2.3 states that courts of a contracting state, like India, but India would be a contracting state in this context, shall refer the parties to arbitration when the parties to an action entered into a written agreement to attribute and one of the parties requests referral to arbitration. The provision, however, does not restrict contracting states from applying domestic law to refer parties to arbitration in other circumstances. That is, Article 2.3 provides that arbitration agreements must be enforced in certain circumstances, but it does not prevent the application of domestic laws that are more generous in enforcing arbitration agreements. Now, please mark this, my lord. Article 2.3, that is unicitral, contains no exclusionary language. It does not state that arbitration agreements shall be enforced only in the identified circumstances. Given that the convention was drafted against the backdrop of domestic law, it would be unnatural to read Article 2.3 to displace domestic doctrines in the absence of exclusionary clause. There has to be a statutory provision excluding the doctrine. In absence, doctrinal approach will be available to the courts while interpreting the arbitration agreement. This interpretation is especially appropriate in the context of Article 2. Far from displacing domestic law, the provision of Article 2 contemplates the use of domestic doctrines to fill the gaps in the convention. For example, Article 2.1 refers to disputes capable of settlement by arbitration, but it does not identify what disputes are arbitrable, leaving that matter to domestic law. Then, my lord, some judgment is cited. Similarly, Article 2.3 states that it does not apply fails to define those terms. Again, the convention requires courts to rely on domestic law to fill the gaps. It does not set out a comprehensive regime that displaces domestic law. Some, the only provision of the convention that addresses, dear lordships, can, my lord, lord, 14. In sum, the only provision of the convention that addresses the enforcement of arbitration agreement is Article 2.3. We do not read the non-exclusive language of that provision to set a ceiling that tacitly precludes the use of domestic law to enforce arbitration agreement. Now, here one can read, my lord, doctrine. There is no exclusion by the statute. Statute could have excluded. Statute could have excluded, subject to, Lord, meeting with your lordship's test if challenged.